Good morning. So now I'm going to try to finish, and honestly, actually try to finish the Elementary Catechism on the Constitution. So yesterday, I meant to finish shit in all in one video. I got about the video ended up being like almost 2 hours long. But I ran out of space on my phone, so it kind of cut out. Fortunately, the way that I typically have been doing these videos, I always do an overlap to where um, it kind of reminds you, like each video remind kind of a brief reminder of what was like the last question that I read before, and then I continue on. So today I'm actually going to go a lot more questions back. I'm going to start with the court and kind of going through the Supreme Court and different court systems and stuff like that. So, question: are courts necessary? Answer: certainly. Wherever laws are made, there must be some way of determining when they have been disobeyed and of causing those who disobey them to be punished. This is the use of a court and of a judge. When one person believes that another has broken the law to his injury or to the injury of the public, he may cause that person to appear before a judge and have it determined by witnesses whether he has broken the law or not. And if he has, he is forced to suffer such a punishment as the law directs. Question: are there courts in every state of the United States? Answer: yes. Each state appoints judges of its own to see that its laws are executed. Question: are there also other courts belonging to no particular state but to the United States? Answer: yes. Question: are all these courts equal or is one superior to another? Answer: they are not all equal, but in each state some of the state courts are set over others, as so it is with the courts of the United States. Question: why are they not all equal? Answer: some are set over others in order that if one makes any mistake, it may be corrected by that above it. When a citizen thinks it has been wronged in a lower court, it may take its cause to a higher one. This is called an appeal. And if it is in this higher court he still thinks he is wronged, he may appeal to a court higher still, until he has gone to the highest court in his own state. Question: can he take his cause from the state courts to the courts of the United States? Answer: no, not unless his cause has to do with a law made by a state which he supposes is contrary to the Constitution of the United States. That questions can be settled only by the Supreme Court of the United States. Question: suppose his cause has to do with the law of the United States and not a state law. Answer: he must go at once to the courts of the United States. Question: what are these? Answer: they consist of one Supreme Court, the highest of all, and of such others courts under this as Congress may from time to time establish. Question: has Congress established any? Answer: yes, it has appointed some which are called circuit courts of the United States, and others below these which are called district courts of the United States. Question: what judges sit in the circuit court of the United States? Answer: the judges of the United States Supreme Court. Question: what judges sit in the district court of the United States? Answer: district judges. Question: what kind of causes are tried in the courts of the United States? Answer: any causes must be tried there in which the dispute is about the true meaning of any part of the Constitution. Question: what else? Answer: all causes under the laws of the United States. Question: any others? Answer: yes. All which depends upon treaties between the United States and nations. Question: what other causes? Answer: all in which ambassadors or other public ministers or consuls sent to the United States by other governments are parties concerned. Question. What others? Answer. All causes which concerns the taking of detaining of ships at sea, and all which concerns crimes committed at sea or in harbors or rivers or in forts and dockyards belonging to the United States. Question. What other causes are tried in these courts? Answer. All disputes in which the United States is a party, all disputes between one state and another state, all in which one of the states sued any person that is the citizen of another of the state, all in which a citizen of one state sues a citizen of another state, all in which citizens of one and the same state lay claim to the land under grants of different states, all in which one of the states sues the citizens of some foreign country, all in which citizens of the United States and citizens of any other country sues each other, but not where citizens of one state sues another state, or where citizens or subjects of a foreign state sues one of the states of the Union. Question. Must all causes of these several kinds be begun in one of the inferior courts of the United States, or may any of them be commenced at once in the Supreme Court? Answer. All cases which have to do with ambassadors, public ministers, and consuls, and all those in which one of the states is a party, may begin in the Supreme Court. The others, after being commenced in the inferior courts of the United States, may be removed to the Supreme Court by an appeal. But this is submitted to the regulation of Congress, who may determine by law when it may be done and in what manner. Question. How are the judges of the courts of the United States appointed? Answer. By the President with the advice and consent of the Senate. Question. How long do they remain in office? Answer. During good behavior, that is, until they resign their office or are turned out of it for some great offense. Question. Why are not judges elected from time to time like members of the House of Representatives and senators? And why may they not be removed from their offices unless they have proved to be guilty of great offense? Answer. If judges held their places at the mere good pleasures of the people, they would be greatly tempted to act in a partial and an improper manner in order to please those who chose them into office, and to keep their favor. But when they know that no man or number of men can turn them out of office so long as they do their duty, they administer justice without fear and with an equal regard to all who ask it. Question. What then should not legislators hold their office? Why then should not legislators hold their offices in the same way? Because they make the laws, while judges only explain and apply them. It may be dangerous to liberty to give our lawmakers power for life. They require restraint lest they should become our tyrants. Therefore, their time of office is made short, so that if the people think them unwise or unfaithful, they may refuse to give them the office again. Sorry, out of the way. Sorry. Okay. Question. Sorry. Yeah. You said that the use of courts are to determine when the laws have been disobeyed, and causing those who have disobeyed them to be punished. How do courts answer this end? Answer. When a person is charged with having done something to his neighbor or to the state which is forbidden by law, the fact is judged of by a jury. Question. What do you mean by a jury? Answer. A company of citizens chosen by the lot and who have no interest in the matter, who listens to the proof brought against the person accused, and who then agrees among themselves whether the accusation has been proven or not. When they declare disagreement in opinion, it is called their verdict. According to this, the cause is decided. So basically, it's innocent until proven guilty. Okay, that's typically what juries are supposed to do going in. They are to convince in their minds that the person is innocent, and the prosecution has to prove that they are guilty. Oftentimes in today's society, we typically have a bad habit of going guilty until proven innocent, and that's not how it's supposed to be. In legal terms, it's supposed to be innocent until proven guilty. So anytime someone makes an accusation, typically in modern society, we typically immediately go, yep, they're guilty, they're guilty. Just shame on them, they need to lose their job, they need all this other crap. Oh, they're so guilty. Any accusation being made. And that's not how we're supposed to do things. It's supposed to be innocent until proven guilty. We do that in personal lives. We do that in court. In the court system, we're not supposed to do that. It's supposed to be innocent until proven guilty. Question: is this a wise regulation? Answer: certainly. The trial by jury is a most precious privilege, as it secures to every man a fair hearing, and is the best safeguard of his liberty, property, and life, all which might be taken from him by a partial or corrupt judge, if that officer alone had to decide on the guilt of or innocence of those who are tried before him. Question: does a jury decide in civil matters as well as in criminal prosecution? Answer: I do not understand the difference between them. Question: by a civil suit, I mean one citizen calling another into court to answer him for some injury committed against him by a criminal prosecution. By a criminal prosecution, I mean a citizen being brought up by a public accuser for some crime committed against society at large, and for which he is liable to public punishment. Answer: a jury decides in both cases. When an officer of the United States is impeached, the accuser is the House of Representatives and the jury is the Senate. But in ordinary prosecutions and suits, the jury consists of 12 people residing near the place where the act was committed. Question: may an accused person be tried in a different state from that where the criminal act was committed? Answer: no. Question: suppose the act was committed at sea or in some other places not within any one of the states of the Union. Where must the trial be held? Answer: where Congress shall have appointed by law. Question: ought all the public acts of a state and all of its courts and officers be recorded in writing? Answer: certainly, not only to preserve a remembrance of them, but that those persons who are affected by these acts may be able to show proof of them, and if injury to obtain redress. Question: when such a record is made in one of the states, and a copy of it duly proved is given, must that record be received as proof by all the other states? Answer: yes, but Congress may determine by law in what manner the record shall be proved for this purpose. Question: when a citizen of one state goes into another state of the Union, may he be treated as if he was a foreigner, or may any difference be made between his privileges and those of the citizens of that state? Answer: no, he shall enjoy every privilege which they do. Again, it's each state is not another country. Okay, so the state is still part of the same. All 50 states are part of one nation. Okay, so just in the case of taxes, or import and exports, there's no tax between states because we're all one country. Okay, so same concept with the way we should be treated in one state should match the way we are treated in another state. So we're not to treat one another as foreigners. If we're all born in the United States, then we're all Americans. If we're all naturalized into the United States, which means we became a citizen of the United States, then we should be treated, regardless of what state we go into, with all the same rights and privileges that any other state honors. Okay? Question. If a person charged with a crime in one state shall flee from justice into the bounds of another state, is he safe from pursuit and trial? Answer. No. If the governor of that state where the crime was committed applies to the governor of the state where he has taken refuge, the latter shall cause him to be delivered up. Well, somebody's governor's been misbehaving now, ain't they? But, oh well. Question. Suppose a slave in one state shall run away from his master and flee into another state. Does he thereby become free? Now, again, there's some of these questions. Like, this was written back in 1828, before the Civil War, before the abolishment of slavery. So, some of these questions are irrelevant. So, in this case, answer no on the application of his master and proof of his being a slave, he must be given up. So, yeah, basically it's saying that the state has to send the runaway slave back to his slave master. However, like I said, that question and answer doesn't apply today because slavery has been abolished, and so yeah. Question: how many states were there when revolted from Great Britain at the Revolution? Answer: 13. Question: did they all agree to the federal constitution at the time it went into operation? Answer: not all, but the rest came in soon after. Question: was it then expected that other states would be formed and join the Union? Answer: yes, and provisions were made for admitting them. Question: by whom were they to be admitted? Answer: by Congress. Question: is their number limited? Answer: no. Question: or their population? Answer: not by the Constitution, but Congress may determine that a district or territory containing 60,000 inhabitants may be received into the Union as a state. Question: then that number of people in any of the states may be erected into a new state? Answer: no. No new state can be formed within the limits of a state already formed. So, case in point, Kentucky was originally part of Virginia. And so, in order for Kentucky to become a state, Virginia had to surrender that part of their state, had to give permission for Kentucky to secede from Virginia to become its own state. So while it was still part of Virginia, Kentucky could not become a state because it was still part of Virginia. But Virginia gave permission to Kentucky to secede from the state of Virginia so that Kentucky could become a state. And there's a lot of good reasons for Kentucky to be cut off from Virginia. First of all, back in the day when Kentucky became a state, well, before Kentucky became a state, in order for, let's say you were here, I'm in Louisville, Kentucky, okay? So if you go from Louisville, Kentucky, you would have, in order to do any state matters, you would have to go all the way to Virginia, to the capital of Virginia, to do any state stuff, okay? That took a lot of time because, for one, you didn't have cars, you didn't have planes. You had to go by either horse and buggy, or not even a horse and buggy, by horse or by foot. That takes quite a bit of time. And so it makes sense for Kentucky to be able to secede from Virginia and become its own state, so that way its capital would be closer to whoever needed to do state business. So, yeah. Question: may two states be united by Congress into one, or parts of two states be erected into a third state? Answer: not unless the legislators of both such states give their consent. Question: when the colonies separated from Great Britain, was their territory all peopled? Answer: no. Large tract of land in several of the states remained in its natural wild state. Question: when the states united under the Constitution, what was done with these wild lands? Answer: they were given up by the several states that owned them and set apart as common property for the good of the whole. Question. What has power to govern these territories as they become settled and to sell the lands to settlers? Answer. The Congress of the United States. Question. Have these since been extensively settled? Answer. Yes, but many new states have been formed within their limits, and many more are expected to be done. They are in the means while divided into several districts proportions called territories, each of which has a form of government suited to its amount of population, and a delegate in the Congress with power to speak but not to vote in that body. Question. Has any state the right to set up a monarchy form of government for itself, that is, a government where the supreme power is in the hands of a king? Answer. No. When the colonies united, they were all republic. The new government they formed for the Union was Republican, and they then secured to every state which has joined or should join the Confederation a republic form of government. So we're all Republicans. Suck it up, Buttercup. Question. Has any state the right to set up a... Sorry, I already did that one. Question. Who is to see that this regulation is carried into effect? Answer. The Congress. Question. Does Congress secure any other privileges to the different states? Answer. Yes, it must protect them from invasion by an enemy. This is one of the most important benefits of our Union. Each state has the protection of the whole. Question. Should unruly persons in any of the states attempt by violence to resist or overturn the state government, and should they gain such strength that the state is not able to quell them, must Congress interfere? Basically, if somebody rises up in rebellion against the state government, is Congress required to interfere? Answer. Yes, if applied to by the governor or legislator of such state, but not to prevent a peaceful alteration of the law attempted in a regular and proper manner. Question. The majority of the people of any state may alter its laws, provided they do not violate the Constitution. But may the Constitution itself be altered? Answer. Yes. The Constitution, being nothing more than expression of the will of the people of the United States, is at all times within its own power, and they may change it as it likes, but it ought not to be changed till it is very clearly shown to be the wish of the people. Question. How is this to be found out? Answer. When 2/3 of the members, both of the Senate and of the House of Representatives, shall agree in opinion that an alteration would be proper, they may state such alteration and propose it to be considered by the people of all the states. The alterations must then be considered by the legislators of each of the states and by the convention in each state, which is a meeting of persons chosen by the people for this particular purpose. And if 3/4 of the states agree to the amendment, it then becomes a part of the Constitution. So basically, this is the amendment process. The Constitution has the ability to be given amended. Case in point, throughout the different videos, I've mentioned the 13th Amendment, which prohibits slavery. This is the process that had to go through. And actually, in the case of the Confederacy, in order for a state that seceded from the Union could be returned back to the Union, it had to agree to accept the 13th, 14th, and 15th Amendment of the Constitution before it could be readmitted into the Union, which prohibits slavery. So, question. But if 3/4 of the states should thus agree to an amendment which would deprive the remaining states against their will of their equal vote in the Senate, would such amendment be binding? Answer. No. This case is provided against in the Constitution, and one other, in relation to slaves, which could only happen previous to the year of 1808. But as that year is now past, no further notice needs to be taken of it. Question. What is the supreme law of the United States? In other words, what is the foundation of our law? What law it supersedes any other law that is made? Answer. The Constitution itself is supreme, and all laws and treaties made by Congress and the President in conformity with it are superior to any law made by one of the states, so that if the law of a state contradicts a law of Congress, the state law is of no force, and the United States law alone must be obeyed. Question. What security have we that the Constitution will be observed? Answer. The President, the members of Congress, the members of all the state legislators, and all public officers of the United States, and of each one of the states, takes an oath when they enter upon their several offices to obey the Constitution. But the great security for its observance lies in the wisdom and excellence of the Constitution itself, and the conviction of the whole people of the United States, that is, for their true interest to observe it inviolate. It has been tried for 50 years and done more to render this nation peacefully, powerfully, and happy than any form of government that has ever existed among men. So you got to remember, he wrote this in a way of celebrating the 50th anniversary of the Constitution. Okay? That's why it was written to begin with. The catechisms were written in honor of the 50th anniversary, the Jubilee year of the Constitution. So that's why this was written. Now, to begin with, so this was written 50 years after the Constitution was written. So he wrote it for you to be able to understand what the Constitution is talking about, and it was written so that little kids could understand what the Constitution says, which is why I read it first. Question. You said that the Constitution, however wise or good, might nevertheless be amended if the people of the United States choose. Answer. Yes, the Constitution says so expressly. Question. Has it been amended? Answer. Yes, several times. Ooh. So now, I'm going to pause a little sec. Now it's finished talking about the Constitution and the different parts of it, as far as like the main part. Now we're about to go into the amendments and talking about the Bill of Rights. Okay, this was written in 1828. So you got the 10 amendments that has been made, plus the others that was made up to the point of 1828. Okay. Question. What was the subject of the First Amendment? Answer. The subject of religious freedom. Question. What do you mean by that? I mean that the right every man has to worship God in such a way as he thinks fit, without being called to account for his opinion or punished for them. Question. Is this a sacred right which ought to be guarded with the greatest care? Answer. Certainly. God alone is the judge of our religious belief and service, and no man has a right to interfere with it, so long as it does not lead us to injure or disturb our neighbor. A great part of the misery and oppression which has existed in the world began with forcing men to do what their conscience disapproves. Question. What amendment was made in the Constitution on this subject? Answer. Congress was forbidden to make any laws respecting an establishment of religion, that is, giving the preference to any form of one religion above another, and making laws to support it, or making laws to prevent men from freely holding or observing any particular form of religious belief and practice. Question. Was any other subject introduced in the same amendment? Answer. Yes, the freedom of speech and the freedom of the press. Question. What do you understand by these expressions? Answer. In a free country like ours, every citizen has the right to express his opinion of the character and conduct of our rulers, and of the laws they make for our government. To forbid this or punish it would be highly dangerous to our liberties. If those chosen by their fellow citizens to rule the state rule in a foolish or wicked manner, it ought to be known that they may be speedily turned out of office, but if no one might find fault with them without danger of punishment, their bad conduct would never be exposed, and they might continue in power to the great injury of us all. The right to speak our opinion is the freedom of speech, and the right to print them, that they may be read by others, is the freedom of the press. Question. But suppose I say of my rulers, what is false or injurious, may I not be punished? So basically, freedom of speech has its limits. If you're knowingly lying about someone, that's called slander and libel, and that is not protected under the Constitution. Answer. Yes, if they can prove it in a court of justice that what you have said is false and that you're saying or publishing it has injured them, so may any of your fellow citizens, but you are still at liberty to speak and to print, being liable to the consequences if you abuse your liberty. Question. If the people shall be of opinion that any of the acts of their rulers have been wrong, may they meet together to petition, that is, publicly to ask that these acts be altered. In other words, freedom to protest. To express, to petition them, hey, yo, that's wrong. You need to kind of abolish that. Answer. Yes, if they meet peaceably, but if they behave in a riotous or disorderly manner, they may and ought to be punished. See, there's the difference between protest peacefully and rioting. Peacefully means you're just saying it, you're not obstructing traffic, you're not destroying personal or public property, you're not smashing windows, you're not destroying, not rioting, you're not acting like a mob. You're acting like a peaceful protest. There's the difference, okay? If you're rioting, then you can be punished by law. There's no protection under the First Amendment. But if you're acting peacefully, if you're peacefully protesting, then you have the right to protest, and no one can charge you against that. That's not breaking the law. That's not civil disobedience. Okay? Civil disobedience is rioting. That's actual legitimate civil disobedience, and that is actually violating the laws of the nation by going and rioting. Okay? There's a difference between peacefully protest and rioting, and this makes it very clear. Okay? Question. May they meet with arms in their hands? Answer. Yes, the right to keep arms and to carry arms is one which belongs to citizens at all times, but arms must not be used except to support the laws or to resist an enemy. Question. As the public safety requires that the government should employ hired soldiers as well as the militia, many of these soldiers be sent to live in the house of any citizen and at his expense without his consent. Answer. Never when the country is at peace. When it is at war, it may often be necessary to do this. But the Constitution declares that even then, it may only be done according to law, not according to the mere good pleasure of an officer of the army, but in a manner which the representatives of the people shall lay down. Meaning, it's basically the Third Amendment. No quartering soldiers. Okay, the Second Amendment is the right to bear arms, which we're legally allowed to have at all times, but arms may not be used except to support the law or to resist an enemy. So basically self-defense and to help preserve the law. Question. Has the government power to enter the house of a citizen and search it and to take him and his papers and his properties at any time it thinks fit? So this is the Fourth Amendment. Answer. No. It is sometimes necessary and proper to seize a man's person and property and to search his papers, but this may never be done until some of his fellow citizens charge him with some offense which would require this to be done, make it appear probable that he is guilty, and swear to what they declare against him. Then a judge gives it to an officer a warrant to search or to seize, but the warrant must say particularly what places are to be searched and what person or property is to be seized. Otherwise, no man would be secure. Meaning the judge has to write exactly what part of the house they can search, if not the whole house, and who, like if they're arresting someone and they're have to do it by warrant, the judge has to it has to be written on the warrant. If it's not on the warrant, then guess what? They're violating your constitutional rights. Question. Suppose I am accused by my neighbor of some crime, which is punished with death. These are called capital crimes, or which would render me infamous in society. Must I be seized and tried because he has accused me? Answer. No. You must be either confined or in some other manner prevented from going away until his accusation is laid before a number of your fellow citizens called a grand jury, who swear to act fairly in the case. They hear your accuser and all the proofs he has to bring against you, and if they think that he is wrong in supposing you guilty and that his proof is not sufficient, they refuse to have you tried, and you are set at liberty. But if they think his proof is such that you ought to be tried, they deliver to the courts what is called a bill of indictment, that is, a paper setting forth the crime you are said to have done, and according to this you are tried, so that no man can be put on his trial till any impartial men think and swear that there is reason to believe he is guilty. Question. Does what you have now said apply to soldiers and sailors in the army and the fleets? Answer. No, they are tried according to certain rules and regulations called Articles of War, to which they swear to submit when they become soldiers or sailors. Question. Does it apply to citizens who are in the militia? Answer. No, not when engaged in actual service. In times of war or public danger, they are then subject to the Articles of War. It applies to them at all other times. Question. What other rights are secured to an accused person? Answer. Whoever is accused of a criminal offense, that means an offense for which he is to be tried by the state, shall be a speedy and public trial. He may not be kept confined longer than it is necessary, nor may he be tried in a secret place, but openly before all who choose to attend. And he shall have a jury of impartial men to try him. The trial by jury has already been explained. In other words, they've already explained it when we were going over the Supreme Court. Okay? The men who compose his jury must be of the same state and of the same district where the offense is said to have been committed. He must be fully informed of the nature of the charges brought against them and how it came to be made. Question. Suppose he knows of persons who would prove him not guilty of the charge, but they live far off and are unwilling to attend his trial. Can he force them to come? Answer. Yes, the court will grant him a certain paper called a writ of subpoena, and send it by an officer to every person he wants as a witness in his favor, and such persons are obligated to come or to be heavily punished. So basically, a subpoena can be sent, and an officer of the law will go and pick them up and force them to come to court to witness in behalf of whatever. They do it for both sides, prosecution and defense. It works both ways. Okay, sorry. Question. Has he other privileges? Answer. Yes, he has a right to have the advice of a lawyer to aid him in his defense and to plead his cause. Meaning he has to the government, if he can't pay for his own defense, then one has to be appointed by the court. That's where public defenders and come into play there. Question: can he be forced to bear witness against himself? This is the Fifth Amendment. Answer: no. Question: if he is once tried and not found guilty, may he be again tried for the same offense? Answer: if it is an offense which is proved against him, would put him in danger of losing his life or suffering any bodily injury, he may not. Question: are my life, liberty, and property guarded by the Constitution so that no man is allowed to touch either of them, except according to the laws of the land? Answer: they are. Question: but if my property is wanted for a useful public object, may it not be taken from me? Answer: yes, but you must be paid the full value of it in money. Question: suppose I am sued by my neighbor about some property, am I to have a jury to try the cause? Answer: yes, and the amount in dispute is more than $20. If the amount in dispute is more than $20. Question: you said that when a person is charged with a criminal offense, he must be confined or otherwise prevented from going away till a grand jury has heard the accusation and the proof against him. How else can he be restrained from going off but by confining him? Answer: by obligating him to bring forward persons who will become his bail. That means who will agree to forfeit a certain sum of money if he goes away and does not return to be tried. Question: who has power to say how much money they shall agree to forfeit? Answer: the judge before whom the man is accused. Basically, they can let you out on bail if they're not confining you in jail, but you have to, if you don't come back, then whoever is basically acting as your guardian, if you will. It has, I don't know. But yeah, there's times they do let you out on bail, but if you don't show up, then there's a lot worse consequences if you don't show up to court on the day you're supposed to show up to court. May he fix any sum he please? This is referring to bail. Answer: no, the sum is to be according to the nature of the crime, the danger of the accused men running away, but it may not be made so great as to be cruel or unjust. Question: any offense ever punished by a fine, that is, by obligating the offender to pay a sum of money? Answer: yes, but here's the same rule applies. The sum must not be made out proportion to the offense and the circumstances, out of proportion to the offense and the circumstances of the offender. Question: may a judge contribute new punishments out of his own head, or orders such as are not in common use for such offense, or has been committed? Answer: no. This basically is referring to the no cruel and unusual punishments. Question: because the Constitution only speaks of certain rights belonging to citizens of the United States, does it follow that citizens have no rights but these? Answer: by no means. Question: has the United States government any powers but such as to contain in the Constitution? Answer: no. Question: have the different states of the Union all the power which rightfully belongs to a state, except those which are denied to them by the Constitution? Answer: yes. When the states united to form the Constitution for their general government, they agreed to give up to that government some of the powers they had before, and they set down in the Constitution what these powers are. All other powers they keep. The same thing is true respecting the people. All the powers they have not given up to the state government or to the general government, they keep in their own hands. And that's the end of the questions. So I will read the conclusion to kind of finish the book. And then, again, remember this was written back in 1828, so some things may be outdated, maybe not. We'll find out, now won't we? Conclusion. And now, my young friends, having gone through a short and I hope clear and intelligible view of this Constitution, I have a few parting words to say to each one of you. In the first place, consider how happy and how highly favored in our country in having a system of government so wisely calculated to secure the life, liberty, and happiness of all its citizens. Had you lived or traveled in other parts of the world, you would be much more sensible of this than you can possibly be without such an opportunity of comparing our lot with that of others. But as your reading increases, particularly in history and in travels, you will be able to form a more just estimate of what you enjoy. When you read of the oppression which has been and still is exercised, I do not say in Africa and Asia, whose inhabitants are but partially civilized, but even in the most enlightened countries of Europe, under absolute monarchs, a proud and haughty nobility, a worldly, selfish, and ambitious priesthood, a vast and rapacious standing army, and a host of greedy officers of government. And then turn your eyes on your own happy home, a land where none of these evils have any place, where the people first make the laws and then obey them, where they can be oppressed by none, but where every man's person's property and privilege are surrounded by law and sacred from everything but justice and the public good. How can you be sufficiently grateful to a benevolent providence, which has thus endowed our country with blessings equally rich and rare? In the next place, remember that this precious Constitution, thus wise, thus just, is your birthright. It has been earned for you by your fathers, who counseled much, labored long, and shed their dearest blood to win it for their children. To them it was the fruit of toil and danger. To you it is a gift. Do not slight it on the account, but prize it as you ought. It is yours. No human power can deprive you of it, but your own folly and wickedness. Basically, if you refuse to read the Constitution, it's your own fault. You don't have protection of the Constitution. Okay? Alrighty. Anyways. To undervalue is one of the surest ways to lose it. Take pains to know what the Constitution is. The more you study, the higher you will esteem it. The better you understand your own rights, the more likely you will be to preserve and guard them. And in the last place, my beloved young countrymen, your country's hope, her treasure, and one day to be her pride and her defense, remember that a Constitution which gives to the people so much freedom and entrusts them with so much power rests for its permanency on their knowledge and virtue. An ignorant people are easily betrayed, and a wicked people can never be ruled by mild influence of their own laws. If you would be free, if you would see your country grow in all that constitutes true greatness, cultivate knowledge, flee from vice, the virtuous citizen is the true noble. He who enlightens his understanding, controls his passions, feels for his country's honor, rejoices in her prosperity, steps forward to aid her in the hour of danger, devote to her advancement the fruits of his mind, and consecrates to her cause his time, his property, and his noblest power. Such a man is one of God's nobility. He needs neither ridden nor star. His country knows and remembers his name, nor could any title add to its honor or to his reward. We have seen such men among us. We hope to see many more. And though the glory of giving to their country such a constitution as this is what none but they have been so blessed as to enjoy, yet you succeed to a task but one degree removed from it, that the persevering what they have committed to your virtue unsullied and unimpaired. And that is the Elementary Catechism of the Constitution. What does all that mean? Read the Constitution. Familiarize yourself. Study it. That is the only way that a corrupt government can be overturned. If everyone knew what the Constitution says, then politicians wouldn't be able to move in a corrupt manner. So, that is all I'm going to say on that. I hope you all have an awesome day. May God lead you to His infinite wisdom. May He inspire you to follow Him. And may you always put your trust in Christ. The Constitution protects that right to put your faith in Christ. I hope you have an awesome day.